Welcome to This Week in Education Law, School Administrator's Guide, episode number 5. Each week, I share up-to-date court decisions on education law. I pay special attention to the court decisions and arguments related to school administrators' daily work. Today, I focus on a case about placing a teacher on administrative leave after the teacher spoke against his school district's policy at a school board meeting. Here is the question. Can a school district suspend a teacher because he publicly criticizes the district policy? Here is the background of the case. Brian Tanner Cross was a health and physical education teacher at Leesburg Elementary School in the Loudon County Public Schools in Virginia. Loudon County School Board was considering adopting policy 8040 entitled Rights of Transgender Students and Gender-Expansive Students. If adopted, the policy would allow students to use a chosen gender identity pronouns different from the pronoun consistent with their biological sex without any substantiating evidence, regardless of the gender recorded in the student permanent education record. The policy would also require school staff to use the name and the pronoun that correspond to students' gender identity rather than their legal name and the pronoun consistent with their biological sex. On May 25, 2021, Cross attended his school district's public meeting. He registered to speak during the public comment portion of the school board meeting. When caught up on, Cross delivered the 50-second remarks. You can find the link of the video recording of his remarks in the description section below. In his remarks, he said, "I am speaking out of love for those who suffer with gender dysphoria." 60 Minutes, this past Sunday, interviewed over 30 young people who transitioned, but they felt led astray because lack of pushback or how easy it was to make physical change to their bodies in just 3 months. They are now detransitioning. It is not my intention to hurt anyone, but there are certain truths that we must face when ready. We condemn school policies like 8040 because it will damage children, defile the holy image of God. I love all of my students, but I'll never lie to them regardless of the consequences. I am a teacher, but I serve God first, and I will not affirm that a biological boy can be a girl and vice versa, because it is against my religion. It is lying to a child. It is abuse to a child. It is sinning against our God. The next day, Cross went to work as usual, but in the evening, the school district's supervisor for equity, compliance, and respectful workplace called Cross and asked him to meet with her the next morning. In the meeting, Cross was informed that he was being placed on administrative leave. He was provided a letter from the school district's interim assistant superintendent for human resources and talent development, who explained that the school board was conducting an investigation of allegations that Cross engaged in conduct that had a disruptive impact on the operations of the school. On the following day of May 28th, through legal counsel, Cross sent a letter to the interim assistant superintendent for human resources and talent development, informing her that the suspension violated Cross' constitutional rights and requesting to be immediately reinstated. The assistant superintendent refused to do so because multiple complaints and parents requested that Cross had no contact with their children because of his comments made at the school board meeting. Cross filed a lawsuit raising First Amendment free speech and free exercise of religion claims, as well as similar claims under the state constitution. The circuit court issued a temporary injunction in favor of the teacher. The school district and its top officials appealed it to the Virginia Supreme Court. In August 2021, the Virginia Supreme Court upheld the lower court's injunction in favor of the teacher who spoke against his school district's transgender policy at a board meeting. The school district was ordered by the court to reinstate the teacher to his position and remove the ban prohibiting him from the school property and events. The court agreed that the teacher made his comments in the public comment portion of the board meeting. In that context, he was a private citizen speaking publicly on a matter of public concern. The court reasoned that it is settled law that the government may not take adverse employment actions against its employees in reprisal for their exercising their right to speak on matters of public concern. How did the court determine that the school district violated its employees' First Amendment rights? It conducted a two-step inquiry. The first step is to ask whether the teacher spoke on an issue of social, political, or other interest to a community. The school district did not dispute that the teacher spoke on an issue of social, political, or other interest to the community. The teacher's speech did not amount to fighting words and were not obscene, but rather were the kind of pure speech to which the First Amendment would provide strong protection. The second step is to weigh the teacher's interest in making his public comments against the school district's interest in providing effective and efficient services to the public. To perform this balancing of interests, the court examined the context in which the teacher made his public comments and the extent to which they disrupted Loudon County Public Schools' operation and mission. Let's first look at the context in which the teacher made his public comments. The teacher spoke in the public comment portion of the board meeting, in which one of the issues under consideration was whether to adopt the transgender policy. The Fourth Circuit has recognized that both the teacher and the public are centrally interested in frank and open discussion of agenda items at public meetings. And the U.S. Supreme Court reasoned that free and unhindered debate on matters of public importance is the core value of the First Amendment. The teacher not only expressed his religious belief, but also expressed his belief that allowing children to transition genders can harm their physical and mental well-being. The court considered it as a matter of obvious and significant interest to Cross as a teacher and to the general public. Speech on sensitive and controversial political subjects that are of profound value and concern to the public, like sexual orientation and gender identity, occupies the highest rung of the hierarchy of First Amendment values and merits special protection. The teacher in this case had a compelling interest in making public comments, as he was opposing a policy that might burden his freedoms of expression and religion by requiring him to speak and interact with students in a way that affirms gender transition, a concept he rejects for secular and spiritual reasons. The fact that an idea may be embraced and advocated by increasing numbers of people is all the more reason to protect the First Amendment rights of those who wish to voice a different view. In this case, the court believed the teacher had a strong claim to the view that his public dissent implicates fundamental societal values deeply embedded in our constitutional republic. After examining the context in which the teacher made his public comments, let's now look at the extent to which they disrupted Loudon County Public Schools' operation and mission. The school district argued that several parents complained, and it was a reasonable expectation that parents and students would avoid interacting with the teacher to the point the teacher could not fulfill his duties. The court reasoned that there was no evidence corroborating the school district's decision of suspension was due to mitigating further disruption. The superintendent's affidavit suggested that the teacher was suspended due to a neutral and generally applicable practice of utilizing suspension or paid administrative leave when an employee engages in speech or conduct that causes a disruption in the operations of the school or school division. The court considered that any such practice would be unconstitutional to the extent the school district deploys it overzealously to thwart protected employee speech. There was another piece of evidence supporting that the school district suspended the teacher not because of disruption. The teacher emailed to the school board and the superintendent, expressing his opposition to and unwillingness to comply with the transgender policy in even stronger terms than his public comments. But the board and the school district administrators took no action. The superintendent even stated that it did not cause any disruption with the operation of the school. The court also noted that the school district suspended the teacher only 3 weeks before the end of the school year and then emailed the entire school community to announce the suspension. To the court, those actions appeared unnecessarily extreme and vindictive. What was the extent of disruption? A few parents requested that the teacher not interact with their children. The court reasoned that where speech occupies the highest rung of First Amendment protection, an employer bears a truly heavy burden to demonstrate that speech was too disruptive to warrant protection. In this case, the teacher was suspended and had restricted access to further school board meetings. The court did not consider the restriction was necessary to prevent the disruption of official functions or to ensure the teacher's effective performance. The school district's interest in providing effective and efficient services to the public should not override the teacher's interest in exercising their constitutional protected right to speak on the proposed transgender policy. Let's summarize the answer to the question I posed at the beginning of the video. Can a school district suspend a teacher who publicly criticized the district policy? A teacher's speech as a private citizen on a matter of public concern is protected under the First Amendment if it outweighs the employer's interest in workplace efficiency and the lack of disruption. This principle was based on a 1968 U.S. Supreme Court decision on Pickering v. Board of Education of Township High School District 205. If you want to know more about this case, check out my video on teachers' First Amendment rights. Here is an update about Loudon County Public Schools in this case. In August 2021, the school district transgender policy was approved by a board by a 7-2 vote, and a lawsuit has been filed to block enforcement of the transgender policy. On November 10, 2021, the school board agreed to a settlement of the teacher Tanner Cross. The school district agreed to pay $20,000 for the teacher's legal fees and remove any reference to the suspension from the teacher's personnel file. I hope this case is helpful for your work as school administrators. I'll see you next week in This Week in Education Law, School Administrator's Guide.